Hello and welcome to Criminal Justice and the Law. Criminal justice and the law breaks down into two main categories. You have criminalistics and you have criminology. Criminalistics is just the facts. This is what happened, how it happened, where it happened. It's literally just the facts. Criminology takes those facts and it adds the why component. So why this happened. Why the person went through it. This looks at their MO or their motives and their traits and their behaviors behind it. There's three types of crime. You have infraction, misdemeanor, and felony. Infractions are very minor offenses. They're typically petty crimes. This would be things like parking on the wrong side of the street, jaywalking, stuff that can give you a ticket or a fine for it. Misdemeanors are more minor crimes. They're less than a felony. These would be things like theft, minor assault and battery, illegal drug possession, or drunk driving. Typically, the punishment is less than 1 year in jail. Fines from anywhere from $250 to $25,000, and then community service is usually tagged on as well. Some of these misdemeanors, when repeated offenses occur of them, so they have multiple thefts or they have multiple drunk drivings counts, then they can become felony offenses. Felonies are very major crimes. These are things like arson, robbery, homicide, rape. Punishments for this are 5 years to life in prison. Death penalty is possible, up to $100,000 fine or higher. They may get probation in some cases, but not in all cases. There are 6 different types of law that we look at when going into court. You have statutory law, which is based on the Constitution. It's the law on the books. The people that administer this are Congress, and these would be examples, would be like the amendments, so the right to bear arms, the national speed limits, stuff like that. Case or common law is used in multiple different types of court cases. This is where they refer to a previous case that has happened in defending their own case. So the judge will administer or accept if the case or common law is okay. For example, if a person isn't read their rights when they are being arrested, their defense attorney would reference Miranda State versus the state of Arizona when defending that person. Civil and criminal law are the ones that we deal with the most in forensics. Civil law is private law. This is where you sue somebody. It's relations between people. It's individual versus individual. This is the stuff that you see on Judge Judy. The judge will make the final call, and this is usually in reference to properties or breach of contracts or damage to a property, stuff like that. Criminal is public law. The judge or jury will administer or make it, and this deals with murders and drugs, felonies, misdemeanors, all of that. Administrative law is stuff that is made by the federal offices, so like the IRS, the military, Social Security. They make their own laws that are then doled out to everybody else. Equity law is for cases that are not covered by common law. This would be things like restraining orders or injunctions and stuff like that. There's 2 main types of law that impact forensics. One is civil and one is criminal. Civil has to deal with some sort of monetary value. This is where, somebody is suing somebody else. Somebody hit somebody on the street, and now they're suing for damages of their car and getting that paid back. They just have to prove that they have preponderance, which means that they have proven that they are just a little bit more right than the other person. They have to be at least 50% or more correct or prove that that person could have created the damage in order to win their case. Criminal, on the other hand, this is state versus individual. The state will prosecute the person that they are accusing. They have to prove that the person is guilty beyond a reasonable doubt, and a jury of their peers will decide the outcome. The Bill of Rights are all of the amendments that deal with how forensics and how we go about processing a person in a trial. The main things are typically the first 5. The right to be presumed innocent until proven guilty, to not be searched unreasonably, to not be arrested without probable cause, against unreasonable seizure of personal property, and against self-incrimination. When you hear people say that they plead the 5th, it means that oftentimes they are guilty of something, but they are not going to admit it in a court of law. When they are guilty of something and they don't want to admit it in a court of law, they say that they plead the 5th. What that does is it allows them to say what they are seeing or what they felt, what they heard at a crime scene without incriminating themselves. So, for instance, if a person is dealing drugs on one corner and they witness a person being shot on the other corner, when they were asked in a court of law what they were doing at the time, they would say, I plead the 5th, because they do not want to admit that they were dealing drugs at the same time that they witnessed somebody being killed. Make sure you know all of the Bill of Rights. They come in handy. They will help a person maintain their innocence, or in some cases help a guilty person be able to get away with their crime. Miranda versus the State of Arizona, 1966, is the defining court case for the rights that you are read when you are arrested. So, what happened was Miranda was a person living in Arizona. They were arrested and accused of kidnapping and raping a person, but Miranda didn't know his rights. He didn't know that he was allowed to ask for an attorney. He didn't know that he had the right to remain silent. And so he ended up confessing to these crimes, even though he didn't commit them. So, as the result of the case, the rights were guaranteed by the Constitution that the police must tell their arrestees about them. These are the rights that are found in the Bill of Rights, but now they are required by the law for police officers to read to the convicted person or to the person that is being arrested. So, most people know them from Law and Order or from watching any other crime scene show after 1966. They started putting it in. If you watch a TV show that has a cop arresting somebody before 1966, they don't read them the Miranda rights. But we all know them. When we're processing a person for a crime, we have to first off prove that a crime was committed. We have to discover the crime. So we have to document and search the crime scene for evidence. We have to identify a suspect. The police will do this in their investigation, and then they will give the report to the prosecutor. When the prosecutor gets the report, they will determine if they have enough information to arrest the person. And if they do, they will send the police out to arrest that person. So they're taken to a police department for booking once they are arrested, and they're also read their Miranda rights at that point. After that, they go to arraignment, which is where they have their first appearance in front of the judge, and they will enter a plea. So guilty, not guilty by reason of insanity, double jeopardy, or nolo contendere, which means no contest. It means that you're not admitting guilt, but you're also not admitting innocence. Bail will be set at this point, and this is usually within 72 hours of being arrested. After that, they can wait for a long time before their preliminary hearing. Sometimes it's a couple weeks. Other times it can be up to close to a year, depending on how backed up the system is. The preliminary hearing happens only if the crime is a felony. It can be done by a judge or a grand jury. This is where the defense can start to cross-examine witnesses and give evidence, and the judge and or the grand jury will decide to dismiss the trial if there's not enough evidence that is proven, or they'll set a date for the trial if there is enough evidence, so they will indict. After that, you have options of either plea bargaining or a court trial. Plea bargaining is where the defense will say, we'll admit guilt if you give us this kind of result. So if we say we're guilty, we'll admit to being guilty if you agree to 20 years to 50 years in jail. If the prosecution comes back and agrees, they will go through that and they won't go through a jury trial or to see the judge. They will just sign paperwork and the person will start their time. If they decide to go to court, they will enter their plea. They will enter the courtroom and try to fight for their innocence. So if they're guilty, it's used to decide the punishment according to the wrongdoing in the court trial. If they're innocent, they will be allowed to go free.